Welcome, Steve.
Thank you. So thank you all for coming today. My name is Steve Bachmann. I'm a patent attorney. I've been working in intellectual property and patent law for about 17 years here in Silicon Valley. My background is electrical engineering. I was a software/hardware engineer at National Semiconductor for a few years before I went to law school. As a patent attorney, I've worked with all types of companies. I worked with larger companies like Microsoft, Sony, Dell. I've also worked with a lot of startups, and that's been my focus over the last 7 or 8 years. I've seen lots of startups with a lot of different approaches, and I've seen how IP, when done correctly, is a positive factor in their approach to being successful. One of my recent companies, AppDynamics, I started with them just 4 years ago. They had a marketing plan, business plan, customer outreach plan from the beginning. And I think just a few months ago, they were acquired by Cisco for nearly $2 billion, I think. So I've seen it happen, and I've seen it fail. And hopefully I can provide you some information that shares the best and what not to do. So with that, and also moving forward, this is what we'll be talking about today. So if you have any questions, please just raise your hand. We can just discuss as we go. So the first thing I'm going to talk about today is kind of intellectual property 101, what some different types of IP are and how they differ from each other. And then I'll talk about why and when a startup might want to consider patent protection. It's not for everybody. And for a lot of companies, it actually makes sense not to file for patents. Pandora had their key technology was the algorithm for selecting different songs based on your preferences. And they never publicized that. It was a trade secret. They never patented it. Because one thing about patents is they're made public either 18 months after you file it or if it's ever issued into a patent. So it's not for everybody, and we'll discuss why you might want to consider a patent if you're a startup. Then we'll get into the patentability of software. This is kind of the nuts and bolts as to what type of software is patentable and what kind of the requirements are. I won't spend a whole lot of time on this because I don't want to put you all to sleep, but we will cover some of the basics. Then we'll talk about the best practices for obtaining a software patent, as well as some of the pitfalls that I've learned over the years. So, and like I said, if anybody has any questions, feel free to let me know. Intellectual property. This is what I've been doing for the last 17 years. Intellectual property is defined as a work or an invention or some other creative act by a person that creates some sort of intangible value. It can be an idea, it could be a name for a product, it could just be an authorship of a work of art. Intellectual property, it's not tangible, you can't really hold it. The way it's implemented or the results of it can be held. For example, a CD with a song or a script or code or an actual product, but it can be assigned and it can be owned just like any other property. So let's get into these types of properties. So the types we're going to talk about today include, obviously, patents. So a patent is a type of IP that protects the utility or design of an invention. Trademarks are another type of intellectual property, and those are typically a name or brand associated with a particular product. Copyrights are another type of intellectual property, and that protects a work of authorship, in particular, that particular implementation of that authorship. And then there's trade secrets. Trade secrets are a right, well, I guess up until recently, you don't really apply for a trade secret. You just do things internally to identify as a trade secret and put processes in place to keep it a secret. A trade secret protects information that's not generally known or reasonably ascertained by a competitor, and it provides economic advantage over your competitors by use of that information. Going into trade secrets versus patents, we could do a whole nother hour, so I just wanted to touch on it briefly. So let's get to the main part of why we're here. Patents. A patent is a government-granted right. So if you come up with a great idea or your invention, whether it's hardware or software, you won't get a patent unless you apply to the US government for it, and it's regional. So a US patent would cover you in the United States. A patent from Germany would cover you in Germany, and so forth. And the way most patents work is, in most countries, is it allows you to prevent others from making, using, or selling the invention that you describe in the patent. So that right to exclude doesn't necessarily allow you to practice the invention. And that's kind of a tricky trade-off. So let's say your invention is, let's say, a laptop computer. And your laptop computer has a housing, a display, a keyboard, and ports. So let's say your patent covers all four of those things. A device for computing and processing code, which includes a housing, a display, a keyboard, and ports. So if somebody else had a patent for something similar, which was just a housing, a display, and the keyboard, but didn't have the ports, you might not be able to use your invention because, based on how their patent was worded, because they included A, B, and C, which would be inclusive of products that include A, B, and C plus other things, as opposed to yours covering A, B, C, and D. So you could both prevent people from using a product that includes A, B, C, and D, but they could also prevent people from using a product with A, B, and C. So with your patent for A, B, C, and D, you could prevent others from doing that. But if somebody has a patent on a subset of your invention, then you might not be able to practice your own invention. So, yeah. So the question was, does it make sense for a person or a startup to try and obtain a patent that is as narrow as possible so you can prevent your patent is as broad as possible? And the answer is yes. That would be a patent of most value. But in obtaining the patent based on prior art that's out there, there's only so much you can do usually. So that's what everybody's goal is usually, is to just get the most valuable patent possible, which means the most narrow patent. And we'll get into how to do that a little later. So I think that answers the question. Okay, a little bit more information about patents. Two of the key requirements for obtaining a patent is it must be novel and it must be non-obvious. So if an inventor is kind of familiar with things in their industry and they think, oh, this is new, nobody's done this, 99.9% of the time they're right. However, to get a patent, it must only be novel, it must also be non-obvious. And so there's a lot of factors and court cases and things that go into non-obviousness. But basically, the requirement is something like, would somebody else skilled in the art, so would another, for example, for the people, most people in this room, or many people, would another software engineer who is trying to solve this product, would it be obvious to them to come up with the exact same solution based on the references or the prior art, the things that have already been done? Based on looking at those things, would it be obvious for them to come up with the exact same solution I did? And it's a gray area. They've tried to codify it, and they have factors to consider. It's a confusing part, but that's the key part. That's one of the key hurdles of getting a patent, is not just that is it novel, but is it non-obvious? So then just a couple other points about patents real quick. Yes? So the question is, if somebody comes up with an invention and they say it's not obvious because nobody's done it in the last 20 years, is that a good reason? Would that satisfy it? So there's a case that lists several factors, and so some of the factors are: did you combine things that had surprising, where the result was a surprising, unexpected result? Did it have exceptional marketing success? Was it a booming product? And another one is, was there a long unsolved need? So if there was a problem out there for 20 years, and then you solved it, that could be a factor to argue that it was not obvious in light of the prior art. Yes? The question was, if you copyright an idea and then somebody tries to patent that idea, what happens? Does everything just explode, or does one have priority over the other? So when you copyright something, you copyright a particular instance of a work of authorship. So an actual set of code, or an actual painting, or an actual song lyrics, or something like that. So what you would copyright is, so let's say if it was software, if you copyrighted software, you would take that code, send it to the USPTO, and they say, okay, this is copyrighted for you. Actually, the copyright is generated automatically if you just write in their copyright, but you can get other benefits if you register it. So if somebody tries to patent it, they wouldn't necessarily patent that code exactly, but the functionality. So, and one aspect of being patentable is it has to be new and non-obvious. So if it was the exact same thing, and you had already done it by proof of the copyright you have, that would serve as prior art and prevent the second person from patenting it. And that would basically be an example of it existed before as prior art, and that's, they decided to copyright it. So therefore, it's not patentable because it's not new. So a couple other quick things about patents. There's two main parts of a patent. There's a description part, which includes some written content as well as the drawings. Just out of curiosity, has anyone here seen a patent or a patent application before? Okay. So you're probably familiar with. There's a written portion, and it's usually accompanied by some drawings. And that kind of describes what the invention is, how it works, maybe the background of it as well. And then there's claims. And the claims specify what you are preventing others from making, using, or selling. So that really specifies the rights that you can assert. And so whether something is patentable, for the purpose of this discussion, we're going to focus on things about the claims. What rules do the claims have to follow? And then just a couple other tidbits about patents. It can be a utility patent or design. So it can kind of protect the functionality of something or just how something looks. For software, it would be most of it would be a utility patent, except for if you want to patent maybe a user interface, or like a screenshot, like Google's homepage. I think they have a design patent on that. And there's also provisional patents versus non-provisional patents. Non-provisional patents are examined by the Patent Office. Provisional patents are usually smaller, less expansive, don't necessarily need claims, and expire in 1 year. So let's talk briefly about other types of IP as well. So like I mentioned, trademarks protect a name associated with a particular product or service. The mark can be a name, a symbol, and it must be distinctive. So generic names usually don't have a very good chance of becoming a trademark unless you have developed some use or association with that product. The mark must be used in interstate commerce. If you use it on the web, that's usually just kind of a check that that'll satisfy that. And it's the protection and the strength of the mark is obtained by use of the mark. So if you just think of something and just file for it, your mark is probably going to be rejected eventually. So what develops the strength in the trademark is using the mark associated with the product. Yes? How long are trademarks active? I believe it varies. I don't have that information offhand right now. Part of the mark's strength is how they use it associated with the product. So if a company goes out of business, they're not using the mark anymore. So then there's no one can contest somebody else who uses that mark. Sure.
So I believe if you fill fees, it's forever, right? Trademark.
I believe so for a trademark. You can extend it. Yes. And then we mentioned copyrights, and there was a question about copyrights earlier. Copyrights protect an original or a reproduced or derivation or distribution of a particular work of art. Standard clauses, things that are widely available, are not determined to be copyrightable. Protects original code in the case of software. And it's created automatically. You don't have to apply to the Copyright Office to protect your copyright. The copyright is automatically granted to you upon generation of the work of authorship. Why would you be motivated to register a copyright? So if you in order to sue, to be engaged in a lawsuit, the copyright, registration has to be filed with the Copyright Office. You can, on the day you file a lawsuit, you can apply for the registration that same day. And also there's additional damages that are available to you if you register the copyright. So I think it's treble the damages. Yes.
And you have
And the question was, if you create something but keep it a secret, are you granted an automatic copyright in it? I believe so, but I would need to confirm that. So. Yes. So the question was, can I talk about briefly about the motivation in the recent change in patent law? So the recent change in patent law, at least in part, was changed that if two people come up with an invention, previously in the United States, and the United States alone, no other foreign countries did this, the person to conceive it first would have priority over anybody else. So even if person A thought of an invention first, person B thought of it later, but filed to the patent office with that invention, and then person A filed later, after person B filed the application, and they tried to claim and protect the exact same thing. Person A previously would have the rights to obtain that patent over, would have prior rights to person B, just because if they could prove they conceived it earlier. Now, it's first to file. So whoever makes it to the patent office first gets the right to that invention. And that's primarily just to align us with most other industrialized countries, which all have first to file. So it's mostly just a confirmation to conform with laws of other countries, since we're all part of the PCT and our laws were different. So.
But the public knowledge and prior art still stays.
Yeah, so the public knowledge and prior art aspects didn't change. It was just if two people had the exact same patent, who would have priority if one thought of it earlier but didn't file, wasn't the first to file. So now let's talk about why you might be interested in a patent. So why might a startup be interested in a patent? And before I get into some of these, there's a lot of reasons why a startup would not be interested, or an individual or anybody might not be interested in a patent. First of all, it's expensive. The filing fees for a patent range from $500 to $1,000. It's a lengthy process. Usually you have to hire a fast-talking attorney like myself. There's a lot of reasons not to, and it takes time. You know, when you have a company and an invention, there's so many things you're trying to do. You're trying to get it produced, trying to get marketing, trying to get advertising, dealing with employment issues, HR issues. It's just another thing to worry about and spend money on. So there's a lot of reasons why not to. So here are some of the reasons why startups, why it might make sense to file a patent. First of all, to attract investment. A lot of VCs in several areas, including a lot of software areas, they want to see or hear you say that, yes, my idea is patent pending at some levels of investment. They just want to reduce the risk that if they spend money in you, nobody else is going to do it faster or cheaper or compete with you. So it's just a way of reducing the risk if you can say, yes, it's patent pending. In my experience, and I've worked with a lot of VCs, they don't read the patents, they don't ask you details, it's just kind of a yes or no. Is it patent pending? Do you have a plan and have you started to implement it? So attracting investment is one reason why patents are useful. Another one is preventing the theft of the innovation by a third party. So what a lot of people might think of patents is, you have a patent on an idea, another company is trying to implement your product, so you sue them to stop. That's really expensive. So patent litigation is often called the game of kings by people who are involved or attorneys who've seen the costs. Patent litigation will typically cost, at best case, $500,000 to sometimes $2 or $3 million, and last 3 or 4 years and end with nobody really being happy. It's just not a good situation. So you definitely don't. So litigation isn't always the first choice. It should usually be the last choice. But there's lots of different ways that you might want to, that your innovation might be taken by third parties. And the way this happens most often for startups is if they get a partnership or a development deal, especially with a bigger company. And these things start off great at first, and then there's licensing terms that don't go right, or for some reason something falls apart. The parties split, and then the company the startup was working with decides, hey, we have enough information, let's just do it ourselves now. Some bigger companies, I won't name them by names, but they're notorious for working with companies saying, we understand you're a startup. We know you're working out of your garage and eating top ramen and popcorn all day. We have, we do 1 million products a year we can implement your technology in. You just have to, we're happy to do it for a year. You just got to give us your source code. Then, they learn everything about the product inside out. Everything's great for a year, maybe 2, and they say, okay, thanks. We decided to go in a different direction. Their engineers know it by now, and then they just do it themselves. And then then you're just looking for a new partner, and they have your product, your technology in there, and you're out. So one reason to have a patent is to prevent theft of your innovation, not so much by a competitor that just comes with it on their own, but more often by a partner that you're contracting with. And if things go bad, you're going to want to prevent them from doing it on their own. Yes? Ideally, if you're doing a joint development with somebody, ideally you can do a trade secret. But a lot of times, if you're going to implement your software or hardware or a mix of that in their product, if they have all the leverage, if all the revenue comes from them, and you need that deal, then you're probably going to give it to them. So it's just you potentially you could have an agreement where they don't have the code, and always you have it in the agreement. They can't take the code, they can't use it. This is a trade secret and proprietary and confidential. But a lot of these big companies are like, I know we signed this, but we have $2 billion in reserves. You have 200,000. You want to go to court? Let's see what happens. Let's see who lasts longer. A lot of times, if there's a contractual agreement or some sort of working together, and then you fall apart, they're probably not going to come after you. They'll probably just go do their thing, and you'll be knocking on their door or kicking them in the leg, coming after them. A big company, instead of suing a smaller company, might be just more likely just to acquire the smaller company. I mean, that's what happens more often, and is often the end goal of a lot of startups anyways. So the question was, can I give a ballpark estimate or guesstimate of what it takes to get a patent? And I wish I could, but it just ranges so much based on the technology and the timeline and how things happen with the patent office. Is it allowed earlier or not? It just varies so much. But I will say that there was a study, I don't have it with me, that an issued patent will generally increase a valuation of a company by anywhere from $500K to $1 million, and it's much, 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 much less than that. So there's one more reason for why, I'll continue with why a startup would want a patent, and that's kind of what we talked about before, to avoid litigation. So not many companies are going to want to go after a startup until they're pretty successful in taking a part of their market share. And if companies that do engage in litigation, they realize that there's a lot of things to consider down the road and what the costs will be, so they're going to do their homework. And one part of the due diligence they're going to do is, do you have any patents? And your patents are probably going to cover or be very close to your product. So if they think that your product is infringing one of their patents, odds are your patent, that the startup's patent is pretty close to theirs as well. So they're just going to be a countersuit. So a lot of times those will even out, or at least cause some damage to the other side, and either help dissuade them from filing a patent litigation suit against you, or at least encourage and expedite a possible settlement between the two. Yes? They help you sleep at night, but it's, at the end of the day, they're very difficult to enforce, and you can sue on them if they are violated, but the damage has been done, and again, the costs of litigation are hundreds of thousands of dollars. So they're better than nothing, but it's not absolute protection. But I always recommend them when dealing with a potential collaborator or client or anything else. And the question was, do non-disclosure agreements make sense? And yes, they do, although they're it's not an iron curtain or an iron shield, but it's better than nothing. So based on what are some good reasons? So when is a good, based on those whys, when would be a good time to file for a patent? So if you're trying to obtain VC funding and you want to tell them it's patent pending, it's best to start 2 to 4 months or so before you're actually going to be meeting with the VCs. I have clients that come. I've had a client actually 3 weeks ago that told me they're going to meet with the VC in like 8 days, and they wanted something on file. We can always do that, but obviously the process goes a lot better if it's not as rushed. You get to meet with not only the company executives, so you learn the business vision, then the engineers, so you learn the technology. You have time to go back and forth. We can always rush things, but ideally, if you can start an application process 2 to 4 months before the VC meeting, then that would be ideal. Question?
Do you prefer a provisional patent first?
For most startups, depending on their stage, yes. I think that the first patent for a startup should almost always be provisional, just because it's cheap. Most often a startup company is just going to want to say something is patent pending, and the provisional application does that. And a lot of times their company isn't, or the technology isn't all the way fleshed out. So when you file a corresponding non-provisional application within a year of that provisional application, you can always add to it. So short answer is, do I recommend provisional applications for startups? I'd say yes, especially as their first application. And then as far as preventing a partner from stealing your technology or ideas if things go bad, file something before you disclose to them. And then as to avoid litigation, when should you file a patent that's going to enable you to help avoid litigation? So a competitor is probably going to consider coming after you if you're hurting them. So if you're taking away their market share, or you're really turning the industry upside down and it looks like you're going to be a huge player and you're going to phase them out. It typically takes, with a normal patent application, it takes 2 to 4 years to get the patent application allowed. You can expedite a patent application, which takes maybe a year and a half off of that. And to expedite it, it's a one-page form and another $2,000 to $4,000 fee, depending on the size of the company. But in order to, if you think your company is got some really good momentum, there's some competitors in the space that are litigious or might feel threatened and come after you, I'd say at least a year or two before you think you're really going to be a threat to them, I would get something on file if you think there is a good chance of them suing. So the question was, why is the wait so long? And it's because they're just understaffed. So the US, right now, when you file a software patent, in most of those technology groups, there's several for different types of software, whether it be machine learning or virtual reality or artificial intelligence, whatever. The wait right now for them to do a thorough examination, their first examination based on prior art, is anywhere from 14 months to 24 months. So just over a year to 2 years before they take a look at it for the first time. And then they'll provide an office action, which is kind of an examination report. You can respond to that, and then it takes them anywhere from 3 to 6 months to get back to you again. So the question is, what counts as a disclosure of an invention for a particular software? So if you were to ship it out, but the code was intertwined or really deep in there, is really hard to get to, would that count as a disclosure? If it was made available to the public, that counts as a disclosure. So if it was on a back-end server, that would probably not be a disclosure. If it was on a mobile device or downloaded onto a customer's computer, that would probably be a disclosure. So the question was, if you file for a provisional patent and don't follow up, would that become prior art? So a provisional patent is kept in confidence, in secret by the US Patent Office, unless a non-provisional application is filed from that and made public. So if you don't do anything and just let your provisional patent expire after 12 months, it just dies and nobody knows you even filed it. Yes, it has to be publicly, like a publicly available document. So a provisional application will likely never, will probably not be made prior art unless a non-provisional application claims priority to it and issues as a patent. Non-provisional patents are typically published 18 months from the earliest priority date. So either 18 months after you file that non-provisional application, or 18 months after the provisional application it claims priority to, if there is one. So once the non-provisional is published, that becomes prior art for other inventions. And the question was, if somebody filed a provisional application and let it go expired, and then a certain time later somebody files a second application, whether provisional or otherwise, would that first provisional application be prior art to the subsequent one? And the answer is no, because it was never made public. It was never accessible by the public. So the person who's associated or has knowledge of that first one might yell and scream, hey, I invented this years ago and filed a provisional. Well, you get part of the process of, let me take a step back. The fact that it wasn't publicly available just means that it's not prior art and won't be considered against later inventions to be considered for patents. Absolutely. And so let me clarify. So if somebody files a provisional application and it expires, it won't be prior art by way of the US Patent Office. If somebody takes that document, who file and say, well, I just don't want anybody else to do it, so I'm just going to publish it. I'm going to put it on my blog or my website or something. The date that it's put on the internet and made available to other people, then it could be prior art. Yes, that would be prior art as well. If you publish a research paper, that would be prior art as well. Okay, so let's move. So I won't spend a whole lot of time at this. It seems, I thought it was too good to be true, but hey, Harvard can't be wrong. There was a study done by Harvard Business School and some students from New York City School of Business regarding startup companies that filed their own patent application and got that patent application allowed, and some things that were just characteristic of those type of companies. So there were several advantages. They had employment growth over a period of 5 years, sales growth increased likelihood to get funded, and even double the likelihood that they were going to be eventually listed on the stock exchange. If you get a patent, should you celebrate that these things are going to happen? No. But it's just, I think, a characteristic of companies that are on this track often get patents. I think it's probably more the reverse that is true rather than, companies with this kind of success probably get patents. So not every company that gets a patent is going to have this, but it's, it kind of works out. But it just goes to show that technology-based companies that acquire patents, apply for their own patents on their own technology and get them, are more likely to be successful and have good things happen to them than those that don't. All right, so now we come to the nerdy stuff that the attorneys like, but might be a little boring for everybody else. So we'll kind of skim through it a little bit unless people have questions. So like we talked about before, there's a couple of main requirements for patentability. There's the novelty requirement and the non-obvious requirement. 99%, I see very few inventions walk into my office where it's not novel. If somebody is excited about an idea and they haven't seen it out there before that's out there, they're probably right. It's probably not out there. It may not necessarily be patentable because it may not be non-obvious in view of the prior art that's already out there. And one key thing about the non-obviousness hurdle is that the Patent Office can combine different references to arrive at something that adds up to yours. One of the key requirements that's come about for software patents over the last year is the patentable subject matter statute, 35 USC 101. So let's talk about that one in a bit more detail. With regards to software, software can be patentable if it's determined to be patent-eligible subject matter. So what does that mean? Well, we know what it doesn't allow. It doesn't allow a law of nature to be patented, doesn't allow natural phenomena to be patented, and it doesn't allow an abstract idea to be patented. And so there's one of those I really want to highlight, and it's the abstract ideas. That's where the key rejections and voiding of patents have stemmed from over the last 3 or 4 years. And most of that has been initiated by a particular Supreme Court case that came down a few years ago called Alice Corp versus CLS Bank. This case was where somebody had a patent for for an escrow company. So they tried to automate the escrow process through online, through a web service, which was normally done just at an escrow office by National Title or any of these other companies. And when it came down, it voided the patent, and then the media jumped on and said, oh, patents aren't, software isn't patentable anymore. This is the end of an era. Everybody can just copy everybody else. That's not necessarily true. It did provide a two-part test. The first is the software directed to an abstract idea? And if it is directed to an abstract idea, does the claim or the recitation of the invention recites something significantly more than that abstract idea to be patentable? So what exactly is an abstract idea or an innovation? Well, the Supreme Court came up with a test, but they said we don't need to define it. That'll happen by somebody else some other day. Yes. So the question was, if the software is directed to an abstract idea, is it just abstract either way? Is it just inherently abstract and not patentable? So that two-part test relates to what the claims in a patent application recite. So not what the code itself does, but what you're trying to patent. So if your claims are directed to an abstract idea, which might be a broad way of doing something with software, then you need to prove that your claims it's not only that abstract idea, but include some elements which result in something more than just that abstract idea. So there's been a lot of confusion, a lot of updates, a lot of clarification from the USPTO. At least once a year they provide some interim guidelines or some examples or some other information that is intended to be helpful, but not necessarily always is. They've given lots of examples regarding what is an abstract idea and what is therefore not patentable. And a lot of it relates to human activities that somebody is trying to do by software. For example, meal planning, or things you can do on paper, but are trying just to automate on software. Basic things that are normally done, that have been done by a human on hand, if you're just reciting those steps, saying, a computer that makes a list of groceries that I need to get at the store in the next week. Something like that is going to be determined a human activity done by a computer and is not going to be patentable. Well-known economic and financial practices, for example, the electronic escrow service, which was the subject of the Alice case, hedging, banking. It's been broadly interpreted to kind of cover any business practice that's been around for 20, 30, 40 years. Trying to implement those things, especially banking, health, and finance, on a computer is going to be very difficult or impossible to get patented. And then mathematical formula. They don't want anyone to discover something in nature and then try and patent it. So like the law of gravity, Einstein's equation of relativity, things like that. You can't patent the basic formula of something. You might be able to patent a product that applies that algorithm in a specific instance to achieve a specific result, but not the high-level formula itself. So the question was, somebody discovered an element at the end of the last century, and he apparently filed a patent on it, and maybe he got it? He got it. So I think that patent would be invalidated if it was ever challenged. So if he ever tried to assert that patent against somebody, I think the defendant would just assert it's invalid on the grounds that it would be, you can't patent a naturally occurring element of nature. So if it was manufactured, then maybe it wasn't naturally occurring. So, yes. So the question was, you can patent the process of manufacturing an element. You can patent the process of manufacturing something, but if you would manufacture it, then I think it wouldn't be naturally occurring because there would be no need to manufacture it. So I think the takeaway, I understand what you're asking. I don't think the takeaway is can you patent the process of manufacturing an element, but I think that you can patent the process of manufacturing something. You can patent something. A product made by a process is patentable. So, but as long as that product is not naturally occurring. So, and the question is a particular company's method of determining a page rank, or like, what order do you list your pages from a search? Would that be patentable? It could be, and I've done things similar to that where, theoretically you could take all that data, crunch the numbers on a piece of paper, and then come up with an output. However, if there's large numbers of calculations, such that it would be if there's lots and lots of calculations, such that it would be overwhelming or extremely prohibitive to do that by hand, then that's an argument for saying that it's not something that you could easily do over and over and over, hundreds or thousands of times a minute for users from all over the network to do. So there is an argument against it that yes, it can be done by hand, but not on the scale that they're doing. So their claims would probably have to incorporate the scale and from the sources of which they're doing it. There's a question? Yes. One way to ward off potential infringers is to say something is patent pending. And there's actual advantages to filing on. You get additional damages if you can show that you put a potential infringer on notice. So you inform them that your product or some product might be covered by a patent. So it sounds like they might have been including a citation from a patent in the software code to put people looking at the code on notice, or maybe it was open source, which was, I don't know, maybe listing some of the patents that it was covered. I would have to see exactly what the citation was and the context to determine for sure why it was there. So. Okay, so let's move forward. So there's several, the USPTO has also given several examples of abstract ideas with elements that actually do amount to significantly more. And they basically relate to the technology itself. So the claim has to be related to a technology, not a business issue, but rather the technology that is novel and non-obvious that addresses that problem. And maybe that technology improves the operation of a computer. Maybe it's tied to a problem that's rooted in technology such as networking or encryption or anything else, any other computer technology. And those USPTO examples of significantly more are all based in case law. Here's the case law on the left. They're all Federal Circuit cases. No one cares about this as much as me, so we'll just skip along. So where does that leave us? Some concepts are simply not patentable for software. Implementing human activities on a computer, you're not going to be able to protect that. Financial and other well-known business practices like escrow, banking, things like that. The U.S. Patent Office is really tough on those just because the practices have been around for so long that they're going to really tough on the rejections and very unlikely to patent things that address those business issues associated with those fields. And then also nearly pure mathematical formulas are also likely not patentable as well. Then as we talked about before, the key takeaways, the concepts that do suggest software patentability are those that are really rooted in technology. Specific improvements the way a computer operates, non-conventional arrangements of known things, unexpected arrangements that achieve an advantage, automated processes that differ from a prior art process, and when it improves the technology, things that are just very much targeted towards the technology are ways or how you get a software patented. So let's move forward to some of the best practices. So here's some of the key takeaways from this talk. Keep a patent application as broad as possible. There was a question earlier saying, do you want to claim a broad patent or a very finite set of elements to make your patent as valuable as possible? Yes, you do as far as the claims. You want them to be as broad as possible. However, when you're drafting the patent application, you shouldn't have your blinders on. Yes, you want to protect what you're doing because you want to make sure you can use it. You want to prevent others from copying exactly what you're doing. But if you are providing if you provide like a GPS box for a car, and there's lots of other competitors with different products, and you have some sort of particular key technology that really sets yours apart. You want to make sure that your patent application, you expand the scope so that you would cover how they would implement that exact same thing as well. You don't want to just focus on your implementation. You want to describe different examples, different embodiments that might take into consideration how a competitor does things. Just so if they were to implement your product or your innovation in their product, they would be covered as well. So the question was, if your patent covers a sewing machine?
No, in the same way what the singer did for the sewing machine, remember the example?
Mm-hmm.
Is it patentable today or not? It's too broad.
Yeah, it would definitely be too broad. So if your patent covered what a Singer sewing machine did 30 or 40 years ago, it would not be patentable based on prior art. So another thing to consider is a focus on software that is most likely to be allowed. So you want to focus on the technology components of your invention. What technology, what does it solve with its technology? How is it improved technology? Because that's what's going to be allowable through the Patent Office. Another tip is to interview the USPTO examiner that's handling your case. To get a patent, there are several rules, guidelines, and there's a process. With everything else, those guidelines and processes are implemented by a person, and generally with one person. There's things you can do to to appeal decisions if you get a rejection you don't like, or go to the examiner's supervisor, but a lot of times that's going to just piss him off, and that's not going to be your first choice to try and move things forward. I had one client at one point in time. It was a company. They had 22 patent applications. 19 of them were with the exact same examiner. I needed to become that guy's friend. So I call them oftentimes regarding the cases, and I would at least always try and make small talk. Hey, I hear and the patent office is out in Alexandria, and the weather out there is atrocious during the winter. So I say, hey, I hear there's an ice storm. How was it getting to work today? So, oh, I'm actually working from home. I said, oh, do you have family there with you? And so I learned his name. I learned his fiance's name. I knew he was going to propose to her before she did. I knew that his sister has kids, and he doesn't really care for kids, but he thinks that's just what people do when they get married, so he's probably going to have kids someday too. I knew, and he knew things about my family, so he just made it personal. And do I ever say, hey, I'm your friend, can you just allow this through? Of course not. But when you make it personal, other things come into play, and it makes it can only help from there. So always call the USPTO examiners.
Isn't that illegal?
No, just small talk is not illegal. Like I said, I never ask him for any favors. I never ask him to not go through the process. But I think calling the PTO examiner to get to know them, educate them about your case, have a willingness to negotiate. So I think one thing that these USPTO examiners hear a lot is just anger and, you're crazy. How do you think that my patent is not patentable based on this prior art? You're crazy. It's not even the same field. Yes. So the question was, is what I do illegal? No, is my answer. We got that on video. I get to know the examiners. I educate them about the case. I make it personal, just so that they want to work with you, and so they're going to find ways within the process to make it work. Most cases that go through an examiner, when an examiner allows a patent application, it's almost always looked at by another supervisory examiner just for quality control purposes. So even if you did get something sneak by, hey, I'll get this through for you. You just buy me a beer sometime you're in town. Somebody else, another set of eyes is going to look at that, so it's not going to get very far. So, all right. The next thing I would say is have a plan. Don't fly by the seat of your pants. Really determine, okay, why do we, is patent protection appropriate, and if so, why? Are we going to go out and try and sue people and keep them off our technology, or are we just going to have them to countersue other people that come after us? What's the budget we want to spend on this? What's the time? What are the goals? Things like that. And then once you have that plan, once a startup has that plan, keep all the key people informed of that plan. So the startups, the engineers, marketing, it just makes it a lot easier and a much better implementation. So now, those were the good things to do, so now some things to avoid. So we had a few questions about public disclosure. Public disclosures can be very damaging, and usually you don't know it's damaging until it's too late. So in the United States, once an invention is made public, you have 12 months to file a patent application on it. After that 12 months, once it's made initially public or offered for sale, it's just public domain, and nobody can patent it in the US. However, the US Patent Office is also first to file. So one requirement of a patent is you have to be a new and original inventor. So if you see something on TV or say, oh, I can't wait to get in the patent office and file something on that, you didn't really invent it. You didn't conceive of that. So theoretically and ideally, if somebody else sees your disclosure, they can't file a patent. However, if you file a patent 6 months after you disclose something and you see that somebody else patented it 4 months earlier and they happen to be at a conference where you disclosed it, it's going to take time and money to prove that they got it from you and that they didn't originally invent it. So it's best just to avoid public disclosures just because in the US it triggers the 12 months. Somebody else could file it ahead of time. And in foreign countries, in most foreign countries, once something is made public, it's not patentable at all. That may not matter for a lot of companies, especially software. The strongest market is US market, so that's the main one. But a lot of times if a startup wants to be acquired by Samsung or Sony or Nokia or some other company that's based in another country, it's going to look much more attractive to them if you do have a patent in their home country. Not always, but sometimes. So if you do a public disclosure, then you don't have a chance of getting that. So. And then open source. Nearly every startup company and most programmers nowadays use open source in some way. And you almost have to be competitive in the market when you're developing a product using teams and such. There's several different types of open source programs and agreements, and a lot of them have requirements for, depending on how you use the open source, you might have to disclose parts of your product, even if it's just interacts with that particular code. Like if you have a mobile app that communicates with server code, in some open source agreements, you might have to make public your server code. So you really got to be careful that you know what open source you're using and how you're using it, so that you're not A, required to give away all your software code, and B, not patenting something that isn't necessarily the open source, but might communicate with the open source and something you're supposed to just donate to the open source community. And then the last one is do it right the first time. I get a lot of inquiries saying, I filed a patent application, I'm not happy, or I received a rejection. I tried to do it myself. Can you fix it? Sometimes it's yes, but most of the time it's no. So you can tweak the claims as you prosecute a patent application. You cannot really add any new content to the description or the figures unless you have other patents that you might be able to incorporate by reference. 90% of the time, once you file an application, you can't add anything new. So you really got to make sure that you've thought about everything you want to include, how you're going to, what your strategy is for moving forward with the patent application, and make sure it's all in there in the first time. So with 5 minutes left, are there any questions? Sir? So if you work for a company and they have a patent, the company goes bankrupt, and then the creditors acquire the assets, who gets the patent? Is that the question? The creditors have it, and they can sell it as they see fit or just let it waste away. That means they own it and just will never assert it. So, yes?
Maybe I'm remembering it wrong, but are APIs patentable? Wasn't there some kind of weird case with Java and APIs? So required licensing because we patented. And it's like, this is an API to it.
Some are, some aren't. That was a very narrow case. The question was, is an API patentable? It depends how standard the API is, what side of the API you're communicating with. It could potentially be patentable, but in some cases they're not. It's kind of a case-by-case basis. Yes?
So I may be misunderstanding. Is there some form of provisional patent where you can file basically anything you want to, and you have like a whole year to really get together and file the real application?
You understood correctly. So the question was, can you file a provisional application, put anything in there you want to, and you have about a year to file a non-provisional application? The answer is yes, that's all true. So a provisional application lasts for a year, and it expires in 12 months. It's never examined by the Patent Office or really even looked at by the Patent Office other than just to make sure the parts are there. To obtain a patent, you need to follow up on that provisional application with a non-provisional application. The non-provisional application is what's going to be examined. The benefit of a provisional application is that you could potentially get an earlier priority date. So you don't really put the time, maybe the effort into drafting, a complete, finely polished non-provisional application, but you get kind of the basics in the provisional application, and the non-provisional application can claim priority to an earlier filing date, which means it might potentially not be subject to as much prior art. The only issue is you have to make sure that the provisional application, even if it's not published, still includes the core concepts to support claiming them in the non-provisional application, if that makes sense. So the disclosure in the provisional application still needs to be thorough enough that it can support basically claims or claim elements in the non-provisional application in order to grant the priority to those claims to the provisional application.
So you cannot add additional claims that are not reflected in the provisional application?
You can. you can add additional claims, you can add additional content, but if it's content that was not described or at least supported for with a straight face in the provisional application, then those claims are only going to have a priority date as of the date you filed the non-provisional application. And the question was prototyping a good way to identify how to put together a provisional? The answer is yes. If you have a prototype, then it sounds like you're on a good track for determining what your product is. But you don't have to have a prototype or a working aspect of an invention. You just have to be able to describe it in enough detail so someone else can make, use, or sell it. Make or use it. Yes? That is correct. When you file for a patent, you don't have to have a prototype. You don't have to have it built. You just have to conceive of enough details so that somebody else can make it and use it based on the information you have in the patent application. No, so a non-provisional application can be a utility or a design, depending on whether it protects functionality or just the appearance of something. So the other option to non-provisional would just be provisional. So there's a provisional and a non-provisional, and a non-provisional can be a utility, which tries to protect a function, or a design, which protects the appearance of something, or a patent application, which affects plants, in my expert opinion. Any other questions? Yes, sir. Yes, it's possible, but that portion you block out, I think there's certain ways for doing that, especially if you're going to submit it to the Copyright Office, but yes, that is an option. A lot of companies firms including mine, will do a prior art search. Those will range anywhere from $500 to $1,500. You could also go to the USPTO website and start searching around. It takes a little bit to get the hang of it, but if you spend some time on it, if you can spend 4 or 5 hours, on the USPTO website, you're probably going to get a decent understanding of what's already out there. Potentially, yeah. If it was novel, and if they made it novel and it was that simplifying it wasn't an obvious thing to do based on the prior process, they could potentially be patentable. If it was a software process, then it would have to claiming that aspect. It would have to be non-obvious over the prior process, and also would have to improve the technology or the function of the computer that implements the process as well. So the question was, do firms that conduct prior art searches include liability insurance? So if they miss something and you're depending on the results of that search to move forward, and then something else actually does come up, can you go after the firm basically and say, hey, you said this is all clear? Any reputable patent practitioner or firm will include malpractice insurance. However, as I have malpractice insurance and I do prior art searches, my malpractice insurance tells me I have to tell people who I do prior art searches for, and based on experience, I tell them anyways. Our search may not cover anything. It may not catch everything. We do the best we can. Some things aren't published, but will be published, after we do the search. And searching is not an exact science. We've been doing it for 10 years. We're very good at it, but you still never know. It can give you a gut instinct, but at some point, if you get a prior search done, you just have to look at the results, whether there's a bullseye or just looks like there's some clouds that might be hiding something. If more searching was done, and you just have to make a call on that sometimes. The question was, do we have to tell the patent office of prior art, or do they do the search themselves? And so they do a very, very thorough search. That's what they're trained to do. That's a big part of their job. You're right. So there's no way they're going to be able to search each and every program that's been written and is out there before. So what they primarily search for is the U.S. Patent Office, prior issued patents, published patent applications, a general Google search, and generally available product searches through some databases that they have access to. Many of those programs that have been written, there's millions, if not billions. They're probably not publicly available. You might be able to find some through open source and other things, but they're not publicly available, each and every one. So unless they are presented to the patent office in some way and shown that they were publicly available, each and every software program is probably not going to be prior art. Thank you all very much. Again, I have cards in the front.